So here's a wild question for you. Can the right to play a round of golf or take a swim actually be a permanent legal right that's attached to your property forever? It sounds a little strange, right? But that's the fascinating question that went all the way to the UK's Supreme Court in the case of the Regency Villas. To really get our heads around this, let's just set the scene. I want you to imagine buying into this beautiful timeshare, a holiday home that you can use for years and years. And it comes with this absolutely fantastic promise. And we're not talking about some small bonus here. We're talking about a promise of a lifetime of perks. Free access to a championship golf course, swimming pools, tennis courts, entry to a country club with beautiful gardens, the whole shebang. For the people buying into the Regency Villas timeshare, this wasn't just some nice to have. It was a huge part of the deal. And here's where it all goes wrong. Years go by, the entire estate gets sold, and bam! The new owners start sending bills to the timeshare holders for using the exact same facilities they were promised for free. All of a sudden, that lifetime of perks has a pretty hefty price tag. And that move sparked a decade-long legal battle over one really important question. Was that original promise just a personal agreement that died with the old owners, or was it a powerful property right that the new owners had to honor? The answer to that entire dispute, it turns out, hinges on this ancient legal concept called an easement. To figure out if those holiday perks were truly permanent, the judges had to dust off the law books and see if they qualified under this very specific, very old area of property law. So what on earth is an easement? Well, think of it like a special right that gets literally bolted on to one piece of land, that's called the dominant land, and it gives that land rights over a neighboring piece of land, the servient land. Now, the absolutely crucial part is that it's a proprietary right. That means it's attached to the land itself, not the person who owns it. It's permanent, and it binds every single future owner of both properties. It's a really big deal. But you can't just call any old right an easement. Nope. It has to pass this really strict 4-point test that was established in another famous case called in re Ellenborough Park. So, 1, you need 2 properties. 2, the right has to actually benefit the land itself, not just be a personal perk. 3, the property's got to have different owners. And 4, the right has to be clear, defined, and, this is key, it can't place too great a burden on the owner of the servient land. The whole Regency Villas case really came down to a fight over points 2 and 4. And this brings us to the big, almost philosophical question for the court. Can a right that's purely for recreation, for fun, can it actually satisfy this strict, old-school legal test? Okay, let's tackle that first point of contention. Does the right to have fun accommodate the land? The timeshare owners argued, of course it does. These are holiday homes. Their whole purpose is recreation. So the right to use recreational facilities is a direct benefit to the property. But the new park owners said, no way. They argued this was a classic case of the tail wagging the dog. They claimed the tiny apartments were just an excuse to use the massive leisure complex. The benefit was personal to the owner. It had nothing to do with the property itself. Then we get to the fourth test, and this one is a real brain twister. You see, an easement can't force the servient landowner to actively do something or spend money. The timeshare owners tried to argue the right was passive. They basically said, look, if the owners stop maintaining the pool, we can just step in and fill it with water ourselves. The park owners countered that this was just ridiculous. A golf course, a swimming pool, these things require constant, expensive, professional management. They argued this right forced them to run a business, which is a massive active burden, and that's something an easement just can't do. So, after years of legal wrangling, the case finally landed in the lap of the Supreme Court. Their final decision was going to be a landmark ruling, but as it turns out, the judges themselves weren't all on the same page. When the verdict came down, the final score was 4-1. A clear majority sided with the timeshare owners. They found that their right to use all those facilities was, in fact, a valid property right. The court officially declared that the right to use the swimming pool, the golf course, and all the other facilities was a valid, permanent easement. And that meant it was bolted to the timeshare properties. It was binding on the new owners of the park. They couldn't charge for access, period. But the reasoning behind the decision is what's really groundbreaking here. Lord Briggs, who wrote the majority opinion, basically said that the law has to adapt to the times. He wrote that recreation is so clearly a beneficial part of modern life that the common law should support it, not just dismiss it as legally unimportant. This was a massive signal that these old laws could and should be interpreted to fit modern lifestyles, like timeshare holidays. But remember, it was a 4-1 decision, and that one judge, Lord Carnwath, had a powerful dissent. He strongly disagreed, arguing that the majority had stretched the ancient law of easements way too far. And he summed up his point brilliantly with this line. He argued that what the timeshare owners were really claiming wasn't a simple property right over land. It was, in effect, permanent membership of a country club, which comes with access to professionally managed services. His core legal argument was that you simply could not enjoy these rights without the park's owner actively participating. A golf course doesn't just exist. It has to be mowed, watered, and managed. A pool needs chemicals and cleaning. This, he said, completely goes against that fundamental principle that an easement has to be passive and can't force the servient owner to spend money or run a whole business. So the timeshare owners won the day, but the debate between the judges raised some huge questions. Let's zoom out and look at why this ruling has a major impact that goes way beyond this one holiday park in the English countryside. The legacy here is actually pretty significant. For starters, this case officially confirms once and for all that purely recreational and sporting rights can be easements. It's also this powerful example of the common law showing it can adapt to modern life. The court even said the right applied to the entire leisure complex, so if the owners built a new, better pool to replace the old one, the timeshare owners would have a right to use that too. This sets a massive precedent for any future property developments with shared gyms, pools, or parks. And really, at the end of the day, this case leaves us with a profound, ongoing question. The majority of judges believed the law must evolve to reflect how we live now, while the dissent warned against bending established legal rules until they break. It forces all of us to ask, how far should centuries-old legal principles be stretched to accommodate our ever-changing world?